Hello, everyone, and thank you for joining us for our program, Environmental Considerations when Siting and Permitting Renewable Energy Projects. My name is Brad Nowak. I'm a partner and co-chair of the Energy Practice Group at Williams Mullen, based in its Tysons, Virginia office. I'm very pleased to be joined this morning by my colleague, Speaker Pollard. Speaker is a partner in our Environment and Natural Resources Practice Group and based in our Richmond office. Speaker helps clients address a vast range of environmental and regulatory issues, including those related to water quality, stormwater management, wetlands, water rights, brownfields, waste management, protected species, and historic resources, among others. He has extensive experience with renewable energy site environmental due diligence and permitting, and has helped clients with offshore wind project environmental considerations. In addition to Speaker, our Environment and Natural Resources team has 13 attorneys across Virginia, North Carolina, and South Carolina who are experienced in all facets of environmental law affecting energy project development and construction, generation, and production. Their experience includes federal and state environmental permitting, enforcement, compliance auditing and counseling, transactional representation, rulemaking, legislative, and litigation. Before we kick off today's program, I have a few housekeeping items to go over today. At any point during the presentation, you can use the Q&A button to ask any questions, and we'll answer them time permitting. If you're having any audio or technical problems, please use that same Q&A button and we'll help resolve those. And finally, you'll receive a copy of today's slide PowerPoint presentation following the webinar. Today's program is our fourth installment of our renewable energy webinar series. If you missed any of our previous webinars, we have the recordings and slides available on our website. We have two other webinars to complete our series, including on June 6th, we'll cover recent trends in real estate options and leases for renewable energy projects. And then we'll also have a webinar on certificates of public convenience and necessity for solar projects, and we'll announce that date very soon. So be on the lookout for invites for those two presentations. Before we begin today's program, I'm just going to do a quick roadmap. We're going to begin by talking about a little bit about the status of the HB 206 implementation, then move to talk about DEQ'S construction stormwater permit program guidance, and also stormwater conveyance easements and permit application review approval tips. We'll also talk about protected species guidance, both at federal and state levels, regulated wetlands update, and finally, environmental justice update. So now let me pass the program off to Speaker.
Thanks, Brad. Appreciate that. I appreciate everybody being here with us today. I'm going to jump right in. We have a lot of ground to cover. Just a kind of a note on the format of some of the slides. I have a fair amount of information in some of these slides. I am not going to be reading these line by line for your benefit, but I do want to make sure that we passed along good information to you in the slides that will be provided. So just wanted to let you know how the format of the slides is set up as opposed to maybe what I'll speak to directly. So the first thing that we're going to unpack is the status of HB 206 and its implementation. As you may recall, this was a piece of legislation that came out last year and directed a process for evaluating impacts and mitigating significant adverse impacts of small renewable energy projects in two distinct ways, or two distinct resources, what are called prime agricultural soils and then also forest lands. Now, these resources are defined and in fact by reference to other agency or statutory definitions, and I've included those here. I'm not going to read through all of those, but suffice it to say is that prime agricultural soils are those that are most productive of all agricultural soils, and they have certain characteristics that you can read through in that definition. I've highlighted some of the most sort of key points there and other factors that are listed in the definition. And the forest land is defined by reference to another code section in the Virginia Code, and basically are called forest trees. And the essence of this is that forest trees are in turn defined mainly as potential immature or mature commercial timber trees. So I just want to make sure that was noted. Ornamental trees are not necessarily those that are covered under forest lands. So those are key definitions to begin with. Next slide. So one of the other things that DEQ was directed to do, the Department of Environmental Quality was directed to do, was to develop amendments to the permit by rule regulations for small renewable energy projects, to do so by December 24, 2024. And these amendments were to kind of put in a little bit more meat on the bone for how HB 206 would work, and to address the steps for evaluation and mitigation plan obligations for those significant adverse impacts. Now, it's important to remember that those impacts, those significant adverse impacts, are themselves defined in three key ways. And they really only apply to disturbances of more than 10 acres of prime agricultural soils, more than 50 acres of contiguous forest lands, or forest lands enrolled in a forestry preservation program pursuant to forestry management program statutory authority. So you really have to fall into one of those categories in order for this to be triggered. And to do that, to kind of help guide DEQ to develop these regulations or these amendments, the statute set up a regulatory advisory panel with a lot of different stakeholders. It was an enormous group, and some of which were named by the statute, and really to help DEQ prepare these amendments to the regulations. And so that was the other key, was another key piece of the statute itself. It's a little unusual to have that level of specificity in the statute. The grandfathering exclusion provision that was in HB 206 is also really important. And it basically excludes from coverage under HB 206 and the regulatory amendments that would flow from it, any small renewable energy project for which that initial interconnection request application has been both received and accepted by the Regional Transmission Organization, which for Virginia, that would be PJM, or the electric utility for very small projects, by December 31st, 2024. So if you have a project that initial interconnection request application has been received and accepted in that regard by that date, then you are excluded from HB 206 by its own terms. Next slide. So what happened with the RAP process? The RAP is the Regulatory Advisory Panel, as we call it. And the RAP was formed last spring into summer and started meeting in earnest a number of times through the summer and into the fall. And there were 4 different work groups that were formed, and I was fortunate enough to be able to serve as co-chair of work group 1. As you see there, work group 1 dealt with avoidance and minimization, and in other words, avoidance of impacts, minimization of impacts. And then work group 2 and 3 essentially were combined, dealing with mitigation planning and how to do mitigation for these impacts, and in lieu mitigation. So 2 different forms, or mitigation might be more like credits or even on-site, and then in lieu with maybe another funding or another way to get credits through alternative means. Work group 4 was charged with defining significant impacts, adverse impacts for projects under 10 acres of prime ag soils or under 50 acres of forest land. So for very small projects, relatively small projects, they had a charge to try to see how those adverse impacts should be addressed. And then work group 5 dealt with local control. In other words, how does the local government fit into this picture through their land use planning and intersection of their authority from locality side with the way DEQ would implement this. So as the RAP process yielded a report that that DEQ rolled into its own interim report to the General Assembly in the fall, late fall, early winter of 2022. I summarized the RAP proceedings and the recommendations and some of the remaining pending issues and actions that needed to be taken. And frankly, because there was not a lot of time to address very complex issues, many of which were highly technical, and for which some data has not really we didn't have enough data to really wrestle with. There were very few areas of consensus developed through that first stage of the RAP process. And there's a fair amount of work remaining. And particularly on those core issues of how do you measure that resource functionality and the valuation of that for purposes of determining mitigation ratios or obligations. So the next thing that would happen in the process is that DEQ will issue a notice of intended regulatory action, or NORWA, and they're expected to do that, I think, fairly soon. I've not seen one issued yet. And that will then kick off the next stage, which is really another RAP, if you will, RAP 2.0, which I understand is going to be much smaller, to really focus in helping DEQ start really drafting regulations based on the earlier work. Next slide. So that was a whole process in and of itself, dealing with one particular set of impacts, kind of layering on the kind of reviews that are already in place for protected species and historic resources. So the HB 206 layers the agricultural and forest land impacts on those, or would do so when the regulations come out. The other thing that DEQ has been very, very busy with, as many of you know, is addressing stormwater program guidance related to solar panels, and also just construction stormwater management generally, which affects how solar projects get developed as well. This started back in the spring of last year with 2 memos that were issued by DEQ, and we actually covered this in the previous iteration of this very webinar last spring, but I'll just kind of recap it very quickly here. So the March 29th, 2022 memo instituted sort of this fundamental policy shift by DEQ that they would treat solar panels as unconnected impervious surfaces for post-development stormwater management. That was a change, and it was a big change. There's a lot of gnashing of teeth and wailing by a lot of folks, and DEQ tried to kind of ameliorate some of that with a follow-up memo that did only so good in that regard, but basically trying to address timelines for when that new policy would become applicable, and set out different timetables for that, basically hinging on interconnection approval by a regional transmission organization or electric utility. So you can see how that was set out there. And again, we covered that about a year ago, but so that sort of laid groundwork, and they noted that DEQ noted that implementation guidance was forthcoming, but there were still a lot of questions and concerns at that time. And it seemed like the overall drive behind this was to help make sure that they were doing whatever they could to help the state meet the Chesapeake Bay total maximum daily load deadline for achieving nutrient and sediment runoff reductions into the Bay watershed. That was a big driver behind this. Next slide. So what has DEQ done since those memos? Well, they started this implementation guidance out. At the same time, they were working on a more broader construction stormwater guidance as well. And eventually they just decided to fold the solar impervious surface guidance, or fleshing that out, into the larger stormwater management guidance that they were working on. And so what they came out with after several iterations that were subjected to public comment, ultimately this came out in what's called the design guide memo, as DEQ calls it, that guidance memo 12/2012, sort of in final iteration, dated November 30th, 2022, that basically sets general technical guidance for construction stormwater for any development, as I said, but it does zero in section 5.500 more technical treatment and timetable of applicability for solar panels as impervious surfaces. And you can see sort of here, there's sort of three different ways it does that. Unless it's directly connected to the stormwater conveyance system, the horizontal projected area of all solar panels will be considered unconnected impervious surface when performing runoff computations for erosion sediment control, as well as for stormwater purposes, post-development stormwater purposes as well. But there is, if you have rain sensing technology on your panels, and they can be dialed in to be completely zero or completely vertical during rain events, then your horizontal projected area may be assumed to be zero. And if there's some angle that you can't quite get to there during the rain event, then you kind of take that into account for how you do your runoff calculations. So they try to at least allow for the fact that if you can get your solar panels angled up during rain events, then you shouldn't have to calculate that as unconnected impervious surface area, which is some help for those systems that have that technology involved. Next slide, please. So if you have if you have sort of a less than vertical position, the operating angle gets used in that regard. But in any event, the supporting posts and columns and beams, those things that are sort of outside of the panel itself profile, they also are considered impervious area for your calculations. So, and then the rain sensor can be programmed to rotate in the rain position. After that a level of rainfall occurs, then that's when you can achieve some of those benefits. Next slide. The other thing that the guide memo does is kind of define better what the interconnection approval, what that means for purposes of this overall guidance for impervious surface area. And basically, if you have issuance of a system impact study as defined in PJM manual, by those dates, then as you can see there, then that's considered interconnection approval. Or if you have an equivalent study by PJM under a process approved by FERC, or if you have a small generator interconnection agreement for projects that go through the state interconnection process, or if you have a submission or acceptance of initial interconnection service application to a regional transmission organization or electric utility. So if you fall into one of those four categories for your project by those dates, then you are outside of the scope of the you're sort of grandfathered out, if you will. Next slide. The other guidance that they issued was more procedurally for how to expedite and streamline stormwater management with plan review and approvals. Again, this applies generally to all development projects, but it is very important for solar projects. And it basically lays out different opportunities to achieve that expedited review based on essentially a professional licensed engineer preparing the stormwater management plan or the erosion sediment control plan in accordance with the license and the design guide, the technical guidance that I mentioned before. And then also that it's sort of pre-reviewed by another person who has a dual combined administrator designation. And then you complete the submission checklist. If you do these things, then you can get an expedited review by DEQ. And there's some other sort of steps in there, or back and forth about turnaround time and so forth that are in the guidance. But this was, I think, generally well received by the development community at large as an opportunity to cut review and approval times. But you need to be very careful that you adhere to the certification requirements, or you have some penalties that can apply to, particularly to the certifying engineers. Next slide. So one other thing I'll touch on really quickly is just as kind of a reminder, really, is that you really have to think about whether or not you're going to need conveyance easements for your stormwater, and really looking at your outfall locations and the rights to use neighboring property. This is just sort of a recurring issue that we're seeing with solar projects and other projects as well. But just to try to make sure that this is on your radar, that you really just have that potential need for those easements, and to bake that into your stormwater management planning. And again, the design guide, the new design guide, does address this issue and the need for easements in particular situations, and addressing sort of particular widths of easements that might be required. So I just wanted to flag that for everybody. Next slide. So a few other tips, just thinking about environmental permit applications, generally, the bottom line here, I won't repeat all of these specifically, but just the bottom line is really start early as you can with your due diligence to define some of these key issues, particularly wetland areas and potential impacts, and your protected species, historic resources, they now prime agro soils and forest lands, and what your mitigation needs might be. Just these things can have a long pole, can be sometimes the long pole in the tent on getting permits approved. And so the earlier you start and address these issues, think about those lead times you're going to need there. Now, there's some tension, I think, that between doing that and your parcel assembly process, knowing which parcels are in or out, and the design of the project itself, the evolution of that design. So, but just know that the sooner you can pull that together, the better you're going to be. Particularly for stormwater and wetlands, just really make sure those calculations, or demonstrate the no adverse impacts downstream. Follow those VRM protocols, runoff reduction method protocols, and think about those offsite areas you might need to offset nutrient loads as necessary, particularly as forest open space agreements that you're going to need in that regard, whether they're on-site or off-site. Give yourself a little wiggle room on stormwater nutrient credits that you're going to need, just to allow for variations in final design. That goes true for wetland mitigation credits as well. Just don't get yourself short. And plan ahead to get these credits, particularly the wetland and stream mitigation credits. There are shortages in many watersheds. You want to make sure you're not get caught, short there and not really having access into these credits. Next slide. So protected species guidance, there has been a lot of activity in this regard. I could spend a whole hour probably unpacking this or more. As most folks on the line probably have heard or experienced, the northern long-eared bat uplisting to endangered species and U.S. Fish and Wildlife Service implementation guidance that has been sort of iterative here over the spring has created a lot of uncertainty and questions about how to go forward. Do I do a bat survey or not? Do I have options to avoid some of these concerns? And the ultimate, or at least the current consultant framework that U.S. Fish and Wildlife issued in as of April 1st, or it would be effective until April 1st, 2024, provides sort of this what I would call sort of a transition guidance or transitional time of how you can do your survey, or how you do your coordination on these issues with federal agencies, permitting. And so just I really, unfortunately, we just don't have time to unpack a lot of that, but just know that there's a lot there that needs to be considered. And many of you have already been through that fire drill probably. Last year, we talked as well about Virginia Department of Wildlife Resources new guidance to facilitate project reviews. That has been out for a while now. I just wanted to flag that as another piece of guidance that's needs to be considered when you're looking at PBR reviews, and looking at the wildlife impact analysis elements that that are part of the PBR permit by rule process for solar projects or other renewable projects, and just thinking about those steps that are listed there, making sure you've got your information in place and ready to go, and not leaving things open that you then have to kind of go back and forth with the agencies on. One thing I'll just flag, really more for offshore wind than anything else, is the DEQ'S putting together a marine mammal protection policy that's required under the Coastal Zone Management Act. and that's evolving right now. So maybe just want to keep your eye on that if you're doing offshore wind. I just wanted to note too that you have federal versus state protected species, and you really have to kind of keep in mind, you have to kind of have your eye on both when you're looking at these issues. So just make sure your protected species surveys are really addressing both categories, and that you have animals and plants. It's not just animals out there. There's plants that can really create issues for you, excuse me, as well. Next slide. Okay, regulated wetlands update. As you probably have heard, there's been a lot of activity on this front with a new definition of waters of the United States, which is the regulatory definition issued by the EPA and the Corps of Engineers for regulated waters under the Clean Water Act for wetland permitting and other things as well. But there's been this sort of ping pong back and forth between administrations over the last 20 years more. Different administrations have their own definitions, and there's court challenges, and invariably there's just a lot of uncertainty. Well, the latest Biden administration EPA core definition change, kind of try to revert back to an earlier time in a sense, kind of reversing some of the Trump administration definition aspects. And the final Biden administration regulation went into effect March 20th, 2023. Again, more inclusive than the Trump era definition, kind of relied back more on the significant nexus determination process that kind of harkens back to the Obama rule, with some differences. But those things were immediately litigated and challenged in court. And so as a result of challenges both in the district court and in the Sixth Circuit Court of Appeals, basically EPA is in the states, there's basically 25 states essentially right now, 24 states in the district courts due to district court determinations. The rule has been suspended or stayed, at least temporarily, through preliminary injunctions. And so EPA is implementing the pre-2015 regulatory regime for waters of the United States in those affected states. This includes Virginia. So right now we're back in the old pre-2015 regulatory regime in Virginia for what is waters of the United States. The other thing I'll just flag is the Sackett 2 case, which is a reprise of an earlier important case before the Supreme Court, was argued in early October. The decision is pending from the Supreme Court. The Supreme Court may very well take up the question of what is the scope of regulated waters under the Clean Water Act, and that may affect, obviously, the definitional outcome as well. Finally, I just wanted to mention that state waters definition is broader than waters of the United States. So even if the feds don't regulate it, DEQ may. So just keep that in mind. It's always something that can play a role. Next slide. Can we go to the next slide? All right, real quickly, environmental justice. I just wanted to touch on this. This is becoming more of an issue for any regulatory actions based at the federal level and the state level. We have a new executive order from on top of several that have come over the years. A new one that was just issued April 21st. Whole of government approach for environmental justice at the federal level pertains to basically any federal activity, and you can see that that's defined very broadly there. And there's a wide-ranging expansion of EJ initiatives and executive orders that have been previously issued, even an EJ scorecard for certain federal agencies that they have to demonstrate how they're doing in implementing environmental justice in their decision-making. At the state level, we have a proposed permitting EJ policy by DEQ. I've included the link there for that. And basically this is going to be a environmental justice policy for DEQ permitting and evaluation of permits of particular concern to environmental justice communities. We had an informal public comment process that just ended. There's going to be a more formal public comment period to follow. DEQ is looking at the informal comments they got and will probably reshape it to some degree. Next slide. So that covers a lot of ground really quickly. And I know we're pretty much at time, but Brad, I don't know if you want to try to squeeze in a question or not at this point for folks.
Yeah, why don't we take a couple questions? I don't think we'll have time to get to everybody's question that's submitted, but we'll get respond after the webinar. But I see that we have a question about the use of livestock, for example, a sheep that graze on solar farm project lands. What issues and concerns can arise?
Yeah, so I know a lot of folks are considering this or maybe even doing it. I would say that one of the things to consider here is how that practice, they're sort of, I would say, quasi-environmental issues there. In terms of livestock in the stream, if you have streams or wetlands on the property, you have to make sure that you want to fence those livestock out. There are best management practices under agricultural best management practices that are established through DEQ programs. There may actually be some funding for some of that if you want. The other thing that I would just say real quickly is be also kind of aware that sort of who's going to be in charge of let's say you use sheep, who's going to own the sheep, who's going to manage the sheep. I think if a solar project owner wants to own and manage the sheep, it raises a lot of other regulatory issues about animal husbandry and other animal care requirements under the Department of Agriculture standards. So you may want to think about how you structure that arrangement with the farmer that has the sheep and maybe figure out, maybe lease the land and let the farmer be responsible. But there's a lot of contract issues there that can come up as part of any leasehold that you may give to a farmer to do that work.
And we've got another question. This might be a longer answer, but what can project developers do to best navigate the various environmental issues and permitting processes for a renewable energy project?
Yeah, so just, that's kind of a big question. I think just given the time we have, I'm just going to say that the best thing you can do is start as soon as you can to identify, somewhat what I said before, start as soon as you can to identify what do you have on the ground in terms of environmental resources, where are they, and how your impacts may affect those resources, and thinking about how to minimize the impacts of through design, how to minimize those impacts on those resources. If you can show that you've done what you can to avoid and minimize those impacts, whether it's wetlands or prime agricultural soils or whatever those kind of resources you have that you're in play, you're going to be positioning yourself for an easier ride through the regulatory process and permit review process. And again, I know there's that tension between due diligence, if you will, and planning this out on the environmental side versus project planning itself and where the solar arrays are going to go, and so forth, and where your internal roads might go, and iterations of the project design. But the stormwater permitting and the wetland permitting are going to probably be the longest poles in your tent on the environmental side, and really may be the longest processes you have regulatory wise as part of even the entire PBR process. So give yourself a lot of lead time to get those things done, so that and lead time in getting those permits issued to meet your project development construction start dates.
I think we'll wrap it up there. Thank you, everybody, for submitting questions. We'll definitely respond to those after the webinar. And I want to thank everybody for attending today's program, and special thanks to the speaker for presenting. If you have any other questions, feel free to email us at energy@williamsmullen.com or contact myself or speaker with the contact information on the screen. And thank you again for attending, and we look forward to seeing you on June 9th.
Thank you, everybody, for being here.